morning, but it's a good one all the same. So we already have 100 in the house. We can get going now. We started off last Monday this week, with this very important topic, cross-examination of witnesses. Now, Farm 21, remind me how far you went. Farm 21, you are our experts in this area. Farm 21, copy. 21. Yes. Taib.
Good morning, Mwalimu. Yesterday, during the last class, we were handling the question on cross-examination of witnesses at trial. If you could grant Elizabeth sharing rights, she can project what we managed to revise.
Okay. Let's hope that Elizabeth now, today, she has resolved her technical issues. Proceed, Elizabeth.
Thank you. Let me share.
Okay, we can see the slides.
Oh, okay, let me check. There's an echo.
Yes, and the screen has disappeared as well. Well, yes, okay, back now.
Sorry, I wanted to mute from that end so that I can get rid of the echo. So we fixed the Luisa Singano questions by removing the tab. So there were no changes there. And then for Said Mohammed, the questions would be, Mr. Mohammed, you are a trader in second-hand clothes at the municipal market. On the day the mic. Okay.
Elizabeth, your audio is not very good.
Okay, can you hear me now? Somebody had unmuted their mic. Can you hear me?
Yes.
Okay, thank you. So, Mr. Said Mohammed, you are a trader in second-hand clothes at the municipal market. On the day in question, you claim you saw two boys, including Desmond Peters, pass by your stall. You say Desmond and his friend are a nuisance. You have complained about them to the police before. You followed them because you saw them carrying a bag. You believe that the boys had stolen the bag. You were about 50 feet away, which is about 15 meters from where the incident happened. You admit that during your case, you lost sight of the boys severally. When you caught Desmond, he was walking, not running. Was he out of breath? Did he have any of the stolen property on him?
Hapana.
With him.
Now, numbers 10 and 11, actually from 9.
Yes.
Number 10, okay, 9 is all right. Number 10, please rephrase number 10.
He was out of breath.
He was not.
Oh, he was not. Okay.
He was not out of breath.
Okay.
Rephrase number 11.
He did not have the stolen property on him.
Of course.
Okay. Shall I proceed?
Of course, we are waiting for you to proceed.
All right.
You don't have to type now. You can change later.
Yes. Thank you. Okay. For Edwin Kwanza, on 5th January 2010 at around 5 p.m., you saw two women pass by your bar just as you were leaving. And these two women were Thila and Luisa Singano. You say two boys quickly snatched a bag from Luisa. The incident occurred a considerable distance away from where you were standing. You only saw the boys for a brief moment before they ran off and disappeared. The boys were both wearing white t-shirts and brown pants. You then saw Said Mohammed run past your door in pursuit of the boys. But when he brought back Desmond was wearing a blue t-shirt. So Desmond was not wearing the same t-shirt as the boys you saw stealing. You know Desmond, but you never saw him during the theft. Did Tila and Louisa say they were only 80% sure that it was Desmond who stole the bag?
Number 12, no. Elizabeth, can you see the problem?
I removed it.
No. What was the problem with number 12? Based on what we had said earlier? How would you rephrase number 12?
Tila and Louisa said they were only 80% sure it was Desmond who stole the bag.
Oh, that's an improvement. You have removed one problem. Another problem, Elizabeth, is that
Yes.
you are dealing with two.
Okay. Yes.
One, deal with one person at a time. I don't want to see the conjunction and at all.
Okay. Yes.
Talk about Louisa. You talk about Thila separately.
Okay. We'll correct that, Mwalimu. Thank you.
Now, number 9. My quarrel with number 9, question number 9 there, is that question is totally unnecessary. Elizabeth.
Yes, sir.
The moment you deal with number 8, And based on what you had asked earlier in number 6, the moment you ask question number 8 there, number 9 is totally unnecessary.
Okay.
Because you have already brought out what?
The
Elizabeth?
concept, I've already brought out the concept of the T-shirt.
No, you have in question number 6 and number 8, you have already brought out what?
The colors.
You have already brought out some inconsistency.
Yes.
Now, in number 9, you are asking for a conclusion. Totally unnecessary. Yes?
Yes, yes, Mwalimu.
That material, you have already elicited enough material for your closing argument.
Okay.
You see the point?
Yes, yes.
So 9 goes.
Thank you. That's well noted, Mwalimu. Thank you. Then lastly, our last for City and Hippo will be Desmond. So you work as a salesperson for your uncle's second-hand clothes business. You mentioned
Move the slides.
I've moved them. I'm on Desmond now. Is it visible or right?
Yes, yes, yes.
Oh, okay, okay, thank you. So Desmond, you work as a salesperson for your uncle's second-hand clothes business. You mentioned in your statement that you have a habit of pickpocketing and stealing when you don't have money for food. Oh my, let me. No tags, no tags. You have never been charged with theft before. You have been arrested and charged with negligence and loitering in the past. On 1st of May 2010 at around 4 p.m., that is 16 hours, you saw a boy hand a purse to another boy who ran away. You were walking behind them at that time. You say the boy who stole the bag is called Mole or Mole. When Said Mohammed caught you, you were walking, not running. Mohammed had threatened to have you and your uncle arrested before over a business dispute.
Now, Elizabeth.
Yes, sir.
I have a problem with those questions. Why? Elizabeth, this is the prosecutor cross-examining Desmond. Yes?
Yes, yes.
Now, what would the prosecutor be focusing on in his cross-examination of Desmond? What would he be focusing on?
Trying to prove that he actually...
He would be focusing on the good facts of the prosecution, the bad facts of the defense. Now, look at your questions there. You know, when Said Mohammed caught you, you are walking, not running. Surely, is that the prosecutor speaking, Elizabeth?
No, no, no. I've seen the problem, sir. This sorry, Mwalimu.
You sound like the defense lawyer doing a re-examination.
Very true, Mwalimu. Sorry for that.
We are disappointed
No, Mwalimu, let's sweep that one under the carpet. I have good ones after this one. I'm sorry, I have good ones. Let me correct my mistake.
This, I mean, Elizabeth, I don't want to hear you speaking in the first person singular. Are you suggesting that this entire task was left by the group to a single member of the group, and that all the other members of the group did not see this problem? I expect this to be a collective, effort of the entire firm. All those questions, you did them with the mindset of the defense lawyer. Those sound like re-examination questions, except that the format of them is wrong. But anyway, let's go on.
Thank you, Mwalimu. Allow me to help. So Faith Mwene, let me handle at least two parties in the Faith Mwene case. So Faith Mwene, you claim to have been married to Alphonse for the last 12 years. The marriage was conducted under Kamba customary law. You agree that full bride price is an essential component for a valid Kamba marriage. Those rights were never completed in your case. So let's talk about the purchase and development of the farm you claim as matrimonial property. You did not sign the sale agreement. You made no direct payments for the purchase of the land. Is it correct that you claim to have contributed to the purchase of the land?
Number 8, no. Don't you remember last Monday, Elizabeth, who was saying, forget about those taglines completely. Those taglines, is it correct? Whether you are putting it at the beginning or at the end of your question, cut out those taglines completely.
Yes, Madam. Sorry, I missed that editing. So it should be, you claim to have contributed to the purchase of the land. You have said that your contribution was limited to the general domestic utilities. You agree with me that you have not provided any breakdown of the specific tasks you carried out. You have
now, once again, all that thing, you agree with me, all that is a tagline. Elizabeth, all that is a tagline. Cut out.
You have not provided any breakdown.
Yeah, start there.
Yes, Malim. Okay. So it should be, you have not provided any breakdown of the specific tasks you carried out. You have no record, receipt, data transaction confirmation of your involvement in the maintenance and contribution. Has so many things. Let me move to the next one. Alice Gashungwa. You met Alphonse while working at the district education office. He told you.
Now. Let's leave Alice for the time being.
Okay.
Let's leave Alice. Let's leave poor Alice alone. Let's leave Alice alone. Okay. There is a good reason why I'm saying we leave Alice for the time being. Okay, you can go to Mwema.
Yes. So Charles Mwema, you have known Alphonse for many years. He paid an initial down payment. There's a question I've removed before that. I wanted to mention that he sold land to him. So maybe I would say you sold land to Alphonse in Makueni. Then I would say now he paid an initial down payment of 50,000. You are not aware how he raised the money. Now, about the sale agreement, you said it only mentioned Alphonse's name. You didn't bother to confirm with him whether he had a wife. So your statement that Alphonse was single when purchasing the land is based on your own assumptions. Therefore,
Number 6, cut out.
okay.
Cut out.
Conclusion. Okay.
That's a conclusion. Totally unnecessary.
Yes, sir. Okay, maybe with this also, I think this one would also be a conclusion, saying that
Yes, absolutely.
yeah, saying that
Absolutely. It's
yeah,
just
yeah,
mere speculation, totally unnecessary.
true, sir. Then I could ask him, you have never seen Faith Moki, and he would say no. Maybe I can stop there for now. I give chance for the other members of the class, because I've already spent 30 minutes. I make the corrections, but I hope the questions today were a bit better. We preached the true gospel.
Now, about Moema, there are some other juicy things you could have brought about. Could have brought up things like the crate of Guinness, that was brought to him by Alphonse, just to spice things up a bit. And so that during re-examination, I can see how the group doing re-exam will deal with the issue of the crate of Guinness. You know?
Yes.
I wish you had brought that up. Okay. Anything else? Any other witness you have, or you are leaving it at that?
Allow me to leave it at that for today.
Okay. Anything else that the group wishes to add?
No, sir. That was the end of our presentation. But we have group members. I see Hussein has raised his hand. They can speak.
Okay.
Good morning, everyone. So would you like us to go through the questions to Jomo Obama, the builder?
Where are they?
I have them here in my thing. I could read them out.
I also have them, only that you would do without the taglines. You'll read without the taglines. I can share them.
But why didn't you make the changes? Just leave them out, because now you have not removed the taglines as agreed.
No, he can read them. He has them. I'm the one who had not finished the editing.
Okay, let's hear them.
You can proceed.
Okay. So Elizabeth, if you do me the favor of not showing Jomo Obama so that I could read from what I've actually made changes from.
No problem. No problem. Just read what you have.
All right. Mr. Obama, you consider yourself a long-time resident of Lanzoni. You mentioned you've lived in Lanzoni since you were 2 years old and rarely leave. You mostly get your information from what people in the village say. You said Alphonse told you that Faith was his wife. You are not personally friends with Faith Mweni. Moving on to your alleged expertise of customary law marriage. You are not familiar.
Hussein? Yes. Obama is the fundi. Obama has not claimed anywhere to have any expertise in customary law marriage. That would be Mzee Kilonzo.
Yes.
Yeah, okay. So there's no suggestion at all that Fundi Obama is an expert in Kamba customs.
Yeah. All right, moving on. I'll ignore that part. And let us move on to the construction and payment. You said Alphonse came to you to build a house on Cowshed. You also said Alphonse paid you some money for construction materials and then paid you little by little afterward. You never received payment directly from Faith. You never entered into any agreement with Faith. You mentioned that Alphonse was the one who showed you the sketch plan and paid you. That would suggest that Alphonse was in control of the project.
Unnecessary.
Mm-hmm.
That question unnecessary.
Yeah. Even though
Hussein, let's be clear. Let's be clear here. Obama is whose witness? Who has called Obama as a witness in this case? Is it Faith or is it Alphonse?
It's Faith.
So you are cross-examining him as Mwoki's lawyer.
Yeah.
Okay, conclude.
Right. Even though Faith may have worked on the farm or sold milk, you don't have any evidence that she paid for or co-owned the land.
Unnecessary. Unnecessary at all. Unnecessary at all. And I want to make this point. Good people, and it's good that Hussein has referred to this. Never ever cross-examine on law, on legal. I don't want to hear language like evidence, language like proof. No, 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 no. All right? So I don't want to hear at all in reference to you have not given any evidence, you have not provided any proof. No, that is material for your closing argument. That is law. That is legalese. Is not the business of the witness at all. So let us note that point very carefully. You know, and I'm going to be saying this point again this morning. You know, there are some lawyers who should be shot on sight. A lawyer saying to the witness in purported cross-examination that, Mr. Witness, if I told you that the law says this, would you agree with me? That kind of lawyer should be shot quickly so that they don't contaminate. Hussein, you have any other question remaining?
Yeah.
Okay, just
some
conclude.
questions on the sketch plan.
Okay. Just leave that out. Just leave that out.
Okay.
Just leave that out. Now, let me. Elizabeth, your hand is up.
Yes, Mwalimu. If I may, allow me to just add something for Charles Mama. I think I have the juicy part that you were talking about, so that maybe you can correct me on the same.
Okay, we will come back to it. We'll come back to it.
Okay.
We'll come back to it. Don't worry.
All right. Thank you, sir.
Okay. Yeah, because we are going to revise. We're going to revise all the weaknesses that you have talked about. The group will revise all of them after the plenary discussion we're about to have. Okay?
Okay,
All right.
Yes.
Now, cross-examination of witnesses at trial. This is such an important area or topic. So important. I mean, some authors have gone as far as saying that cross-examination is the reason advocates exist. It's so important. But we must get it right. We must get it right. Every law student dreams of the day they will get admitted to the bar, and they can't wait to cross-examine their first witness. They can't wait. And I know that is true of you there, seated there this morning. Not a single lawyer, well, not a single law student dreams of doing a great examination in chief. None whatsoever. The examination in chief is extremely boring. It is boring. It is not dramatic. It is not sexy. It's just boring. Nobody dreams of doing it. Yet, as we have already said in the last couple of weeks, examination in chief is when we actually present to the fact finder the material in support of our client's case. Cases are won or lost not because of a great cross-examination, but because of a great examination in chief. So I want to begin this morning by disappointing you people. I want to begin by disappointing you, by telling you, if you think that you are seated there to learn how to do a great cross-examination and then that way you can win your cases, I am sorry. I want to disappoint you. So I want to begin with that disappointment, that what wins our cases is not a great cross-examination, rather a great examination in chief. But that is not in any way to understate or underestimate the importance of cross-examination in the whole trial business. But I want to begin with this caution. I want to begin with this caution. Many lawyers have the wrong approach in terms of the mentality as to what cross-examination is all about. Perhaps they are misled by this word cross. They are misled by this word cross. And they get the erroneous conclusion that cross-examination is about examining crossly. It's about examining crossly. You are wrong. Which reminds me, when you are writing this term cross-examination, you must hyphenate it. You must hyphenate. If you don't hyphenate and you write it as 2 words, you are saying something completely different. You are actually saying to examine crossly, you know, cross examination. Is you are suggesting that this is to examine in a cross manner. You be very careful. It is one hyphenated word. If you omit that hyphen, you change the meaning of the whole thing completely. So be very careful. You must hyphenate. So for us in Kenya here, we still use that old British nomenclature, cross-examination. The Americans prefer to call this indirect examination. Indirect. So if you read American literature on this subject, you are likely to see indirect examination. And so, what is cross-examination? Now, I know this may surprise, may surprise. Let me do a quick test here. Let me do a very quick test. Irene Macau. Irene Macau. Switch on your camera, microphone, Irene. Yes,
Done.
Irene. Yes. What is cross-examination, Irene? Ala?
Sorry, morning. So cross-examination is a process of calling witnesses and questioning them.
Nonsense. 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 Rubbish. Hey, hey, hey. I'm not surprised at all. Joroge John. John Joroge, you turn your microphone. Joroge John.
Yes, good morning.
What is cross-examination?
Okay. It's I will say cross-examination. It's examination of the other party's witnesses to poke hole.
Nonsense. Nonsense. I'm not surprised at all. I'm not surprised at all. Veer. I don't know how you pronounce your name. Shah, please help us.
Morning, it's Veer. Yeah, you pronounced it correctly.
Okay. So, Mr. Shah, what is cross-examination?
It is the calling of witness. It is the questioning of witnesses called by the opposition in order to question their credibility or poke holes in their statement.
No. Now you see, let me tell you, every oral examination season, I get to hear some of my colleagues asking the candidate, what is cross-examination? And invariably, well, for me, I would never ask questions like those. Never. Instead, for me, you will find me standing in the witness box. I tell you, my name is Said Mohammed. Cross-examine me. But my colleagues, some of my colleagues, I hear them asking the candidate, what is cross-examination? And exactly what you have heard here are the sort of answers I hear. Some even will be heard saying, I have heard students saying the cross-examination is where the prosecution witnesses are questioned by the defense lawyer. Thank you. Nonsense. Nonsense. I mean, let's please, let's get our things right. Cross-examination is defined for us by the Evidence Act. And the group mentioned this last Monday is there in section 145, yet nobody bothered to take note. Cross-examination is the examination of a witness by the adverse party. By the adverse party. It is not about the opposition, it's not about the other side, it's not about the opposing side. Excuse me. Adverse party. Don't you know that one accused person can cross-examine your fellow co-accused? Are you on opposing sides? No. Both of you are accused persons. You know, when you say opposing side, you are suggesting prosecution, defense. Don't you know that one defendant in a civil suit can cross-examine a co-defendant in the same civil suit? So let us be clear from the word go. Examination of a witness by the adverse party. The story of one co-accused in a criminal case can be adverse to that of a co-accused. The story of one defendant in a civil suit can be adverse to that of a fellow defendant. So let's be clear about the meaning of cross-examination. Let's be clear, even as we discuss certain basic concepts about cross-examination. So, yes, I repeat, cross-examination is important. Very important indeed. However, it is optional. Cross-examination is optional. That might surprise some of you who imagine that every single witness called by the adverse party must be cross-examined. No. No, 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 no. You only decide to cross-examine a witness if it is necessary. That's it. That's it. Yes, it is so important. But what is rule number one? Don't do it. Rule number one is don't do it. Important as it is. Indeed, so important, so important is cross-examination that no less a place than the Bible itself tells us in the book of Proverbs, chapter 18, verses 17, that the first person to speak in a court of law sounds truthful until they are subjected to cross-examination. Hallelujah. Oh yes, it's there in the Bible.
Amen.
It is there.
Amen.
The first person to speak sounds truthful until they are subjected to cross-examination. Yes, it is important. And it, of course, as a constitutional imperative, is part of the fair hearing processes, the right to challenge evidence. Now, why do we do a cross-examination at all? We are saying it's optional, but very important. So why do we choose to do it at all? Overall, we seek to achieve two objectives: to advance our own case, even as we seek to weaken or detract from that of the opposing side. You only choose to cross-examine a certain witness if you think that some value will be added to your story by strengthening your own case, even as you weaken that of the opposing side. So that your aim is to extract information from the opponent's witnesses which is beneficial to your case. If you cannot achieve that, then for heaven's sake, for the sake of getting to heaven, please don't cross-examine at all. Otherwise, you will never go to heaven. Eh? Of course, we do our cross-examination, good people, based on our pre-trial preparation. Never forget that. Never forget that. Remember when we did this discussion about preparation for trial, we were saying that one of the products of our pre-trial case analysis is to prepare, decide how we shall conduct our witness examinations, all the three stages of it, so that long before you go to do the trial, you are clear in your mind. For this particular witness of the other side, I would wish to challenge them about this. In advance, you know. So it's not a decision you make in the courtroom on the spur of the moment. Not quite. I always like telling my students this story, not to spite our poor people who are the majority, but just to illustrate the point of why we are saying that you only do a cross-examination if it is necessary. This is an accused person in a criminal case. It's an offense of assault. Now, the doctor who examined the complainant has come to testify, and they have produced the P3 form. This poor accused person is not represented by counsel. So after the doctor is finished, the court says, as required by the law, of course, the court says to this accused person, uko na maswali yoyote kwa daktari? Ndiyo mheshimiwa, niko na swali. Haya, uliza. Wewe daktari unanijua? Hapana. Unajua mahali mimi ninaishi? Hapana. Unajua ile kazi mimi ninafanya? Hapana. Ulikuwepo siku hiyo kitendo kikifanyika? Hapana. Na halafu unakuja kutoa ushahidi kwa kesi yangu namna gani? Sina swali lingine mheshimiwa. Now, that's a sad story. And you hear that in our criminal courts every single day. Sad. Now that guy assumes he's doing a cross-examination. Unfortunately, that is not cross-examination. It isn't. It isn't. And as I keep saying, you know what the tragedy is? The tragedy is you will hear lawyers, trained lawyers, LLB honors, diploma in legal practice, Kenya School of Law, doing something exactly like that, if not worse. These are the lawyers, I'm telling you, assume that every witness must be cross-examined. You want to impress your client or the gallery or whoever, I don't know, that you must be seen to be doing something. I'm sorry, that's not the thing. So, take that example I've just given there, and you are the lawyer of that accused fellow there, charged with assault. Now, look, in a case like that, your client, upon pleading not guilty, would be saying one of two things. Your case theory can be one of two things. A, it wasn't me. I did not assault the complainant. I wasn't even there, or even if I was there, I did not assault the complainant. It wasn't me. Number two, your client, the accused, could be saying, well, there was a bit of an altercation, yes, and, you know, a bit of some physical confrontation, but I acted in self-defense. I acted out of provocation. Aha. Aha. So in this second scenario, your client is saying, yes, I did the act complained of, but I have a legal justification for what I did, therefore taking away the mens rea. Now, good people, come with me here. In scenario number 1, you as the defense lawyer there, will you need to cross-examine the good doctor on the contents of the P3 form, the extent of the injuries sustained by the complainant? I say to you, no. I say to you, no. Excuse me. What is your aim? If your case theory is no, my client did not assault the complainant at all, then what business do you have cross-examining the good doctor? I say none whatsoever. I say none whatsoever. But in this second scenario, where your case theory is self-defense, provocation, aha! Now, there you have every interest in cross-examining the good doctor. Oh yes, because the issue of the extent of the injuries is materially critical for this case. I don't know if I'm making a point here. And all that I'm doing is to say to you, cross-examination is optional. Important as it is, you only choose to do it if you must. If you must. It is not every witness called by the other side or by the adverse party who must be cross-examined. No, no, no. It is okay to say to the court, Your Honor, I have no questions for this witness. Of course. Now, there are some scholars who say, I suppose some of you may have seen this in your reading, that there are two situations where you may choose not to cross-examine at all. One, if the evidence in chief has not done any harm at all to your case. This particular witness has not said anything adverse to your client and their case. You see, take the situation of a criminal case with 5, 6, 7, 8, 9, 10 accused persons. You are representing accused number 7. This witness comes, testifies about the case, prosecution witness. They say things about several of the accused persons, but zero about your client. Now, during cross-examination session, the court will be saying, counsel for witness 7, any cross-examination? It's okay for you to say, no, Your Honor, no questions for this witness. They have not mentioned your client. They have not said anything adverse about him or her. So why the hell would you want to do any cross-examination? No reason at all. But I want to again make this observation that even though you people are dreaming of your day one of cross-examination, which is okay, dreams are great. I want to caution you that cross-examination is an inherently risky affair. It sounds sexy, it sounds great, it sounds, oh, but it is risky. How? If you are not careful, the witness will argue with you. Bad idea. If you are not careful, the witness would take advantage of your poor cross-examination to fill gaps in his story that were left out in the examination in chief. I'm sorry. If you are not careful, you may make yourself look really, really bad. In any event, good people, as we shall see in the coming days, and I'm sure Farm 22 is waiting to say this to us, even a very good cross-examination can be cured by a very good re-examination. Hello? So yes, cross-exam is a great thing, but, well, it is not necessarily what wins cases for us. No. But yes, it can go a long way. It can go a long way. So, why are we doing a cross-examination? To advance our own case, even as we seek to weaken that of the other side. But what is the Evidence Act telling us about the aim of cross-examination? It is twofold. Number one, to test the accuracy or veracity of the testimony given by the witness in their evidence in chief, of course. And number two, to test the credibility of the witness. That's precisely what we are doing. We are testing two things. Now, this is not my language, this is the Evidence Act. I see some people saying that, oh, the purpose of cross-examination is to discredit. Hapana. It is to test. It is to test, number one, the accuracy or veracity of the testimony given by the witness. Number two, to test the credibility of the witness himself. And we're going to see this shortly. I know there's something I asked from this is from what, 20? I'll remember just now. Look, yes, witnesses swear or affirm to tell the truth, the whole truth, and nothing but the truth. So God help them. But you know what, good people? Even after that great oath or affirmation, nevertheless, sometimes witnesses say things that are not the truth, that are not the whole truth, and sometimes things that are not that are truth, plus some things that are not the truth. The oath is the truth, the whole truth, and nothing but the truth. Three things. But for a variety of reasons, sometimes witnesses say things that don't really pay homage to that oath. The witness may be mistaken. The witness may have forgotten. The witness may have misinterpreted something. The witness may be acting out of fear. The witness may be, in worst case scenario, lying through their teeth, as they often do. Therefore, this cross-examination business of ours aims to test how accurate is the testimony given by the witness in chief. How credible is this witness? You know, you want to enhance your case even as you detract from that of the opposing side. Of course, if you're going to be presenting certain documents through your own witnesses, you can actually take advantage of a cross-examination to establish a foundation for such documents. So, I want to mention two important points from the Evidence Act. Point number one, scope of cross-examination. The scope of cross-examination is very, very wide. What do we mean by this? Section 146(2) of the Evidence Act is telling us that the examination in chief and the cross-examination must relate to relevant facts. Both of them must relate to relevant facts, but the cross-examination need not be confined to the facts to which the witness testified in the examination in chief. Aha. That's a crucial preliminary point. Once upon a time, many, many years ago, I was doing a small criminal case at Makadara Law Courts down Nogoro. And this young lawyer, so I was seated in court waiting for my case to start. And ahead of my case, there was a defense hearing. Criminal case, there was a defense hearing. This young lawyer has called a defense witness, has examined this witness in chief, giving a sworn testimony. I think it was the accused person. Then they are finished, and the prosecutor stands up to cross-examine this defense witness. And 1-2 questions into the cross-exam, the young defense lawyer shoots up, "Objection, Your Honor." "Counsel, what is it?" asks the magistrate. Young lawyer says, "Your Honor, I did not ask the witness about those things, so the prosecutor cannot cross-examine about them." "Oh, magistrate, Mr. So-and-so, but this is cross-examination. Do you have your Evidence Act?" Now, the poor young lawyer did not even have it. Those were days before we had these things on the internet. So the good old magistrate quickly advises the young lawyer, "This is cross-examination. Prosecutor, proceed." It's very embarrassing. The cross-examiner has a completely wide latitude, which is the cross-examiner can ask the witness anything and everything under the sun, so long as it is relevant to the facts in issue. That's it, Section 146(2) of the Evidence Act. The cross-examiner, I repeat, is not confined to the things that the witness was asked during examination in chief. No. So long as it is relevant, you can ask it. And that is why, as we shall see with Farm 21 shortly, 22, I think, 22, that is why it's part of the reason why we have this other room for re-examination. It's part of the reason. And now, when we come to discuss that re-exam business, we shall be seeing that the re-exam has a very, very narrow scope, which is that the re-exam is confined to the things that the witness was asked during cross-examination. You see? So that's point number one, the scope of cross-examination. The point number two that I want to make is this. Section 151 of the Evidence Act, which is actually, surprise, surprise, the shortest section in the entire Evidence Act, which says leading questions may be asked in cross-examination, full stop. Interesting. Interesting. Leading questions may be asked in cross-examination. Now, I want to give you people this piece of advice, which is, let us take full advantage of Section 151 of the Evidence Act. Let us take full advantage of it and read it as if it is saying to us, read it as if it is saying to us, leading questions only. Oh yes. Oh yes. Let us take full advantage. Full. And read it as if it is saying to us, leading questions only. That's free advice I'm giving you this morning. Free advice. Because that way we will achieve our objective of quote, quote, putting our case to opposing witnesses. Putting our case to opposing witnesses. The law is permitting these leading questions because, look, opposing witnesses will have very little incentive to cooperate with you, the cross-examiner. I can assure you of that. You know what some lawyers tell their witnesses in preparation for court hearing is that, well, I will ask you some questions. When I'm finished, the lawyer for the other side is likely to ask you some few nasty questions. So be prepared. Can ask, he's a very bad man. We'll ask you some stupid, nasty questions. So witness is already poisoned. Witness is already poisoned that this lawyer of the other side is the enemy. In fact, can I tell you that clients dislike the lawyers of their opponent more than they dislike their opponent. That might surprise you, but it is the truth, the whole truth, and nothing but the truth. So God help you. Clients hate the lawyers of their opponents more than they hate their opponents. Yeah. So they have little incentive to cooperate with you. In any event, you have not had any prior interview with them. You haven't. Well, you may have read their witness statement, that's okay. So you may have a fairly good idea of what it is that they will be saying, although, of course, they may also, in the examining chief, they may say some things that were not necessarily in the witness statement. So the law is permitting us to ask them leading questions. Take maximum advantage of that, I say to you, and therefore we have our new mantra this morning for cross-examination, which is the following: let all our questions in cross-examination be one fact leading questions. Hello? I trust that everyone remembers our earlier mantra on exam in chief. So this morning we have our new mantra for cross-exam, which is one fact leading questions. One fact. Now, note carefully, good people, when I say one fact, I mean two things. Number one, actually one only, not two. Secondly, fact only, not conclusions. And that is why you have heard me point out those two things to Farm 20 here, where they are tempted to mix more than one fact, and two, where they were asking a witness for a conclusion instead of a fact. One fact leading questions. Now, when I say leading questions in this respect, for the examining chief, I gave you this useful tip of starting oral questions with our famous W's, the 5 of them, and the H. And of course, we also saw that occasionally, where appropriate, please describe, please explain is acceptable. Now, today, I want to give you an extra tip, this time for leading questions. That was earlier on how to avoid leading questions. Now today, we are doing the opposite. How to do leading questions. Interesting stuff, isn't it? Look, good people, these are our storytelling rules. I'm not the one who wrote them. I didn't write. The evidence that, I mean, when I was born, it was already there. So, how then do we structure our questions so as to take full advantage of 151? I said to you, I know last time I banned the to be verb. Did you? Can you? Will you? Could you? Etc. I continue banning them even today. Yes, I said that those sort of questions are invariably leading by their very nature. Yes, I agree. But for our purposes of cross-exam, I want to suggest something very powerful, which is make a statement. Make a statement. Let the witness agree or disagree with you. Monica, as a class rep, you should lead by example, not interrupting us. Okay? Now, make a statement. Let the witness agree or disagree with you. Make a statement. Let the witness agree or disagree with you. What do I mean by this? Mr. Mohammed, as you chased the boys, you lost sight of them a couple of times. When you caught Desmond, he was not running. In fact, he was not out of breath. Mr. Mohammed, you did not find Louisa's purse with Desmond. Good people, the purpose of cross-examination essentially is, quote, quote, to put your case to opposing witnesses. And you see, your cross-exam is based on the good facts, bad facts analysis that you did at pre-trial. It is not from there. It's not come from there. Miss Singano, you wear glasses. You cannot see long distances. On this day, Miss Singano, you're not wearing your glasses. Look, from the tone of my voice, you can hear that that's a question. But it is a statement. And you can also hear no need at all for any taglines. You did not see no need for did you. You did not hear no need for did you. You did not go. Forget about the taglines. Make a statement, let the witness agree or disagree with you. Whether they say yes or no doesn't matter. You have made your point. And you see, at the end of the day, it is up to the court, upon evaluating the totality of the evidence, to now determine where the truth lies. Truth, truth, truth. That word again, if you remember our day one in this class, we started with the search for the truth. We are still searching for it. Make a statement, let the witness agree or disagree with you. Your questions are based on the good facts, bad facts analysis. And of course, you want to hammer on the good facts. You want to hammer on the good facts of your case. Now, there are 1,000,001 do's and don'ts in cross-examination. There are 1,000,001 do's and don'ts in cross-examination. So many. And I want to challenge everyone here. As part of your homework, I would want everybody to take a moment, write down, just for your own training, write down a list of, on one hand, not less than 10 do's, not less than 10 don'ts in cross-examination. And I consider our good friend Ian Morley. I think the group spoke about this. Our good friend Ian Morley, in that little book of his called The Devil's Advocate. Advocatus Diaboli. Huh? Those of you who are Catholics will be familiar with that expression, Advocatus Diaboli. That's where Ian Morley borrowed that title of that book from. You can go and Google that your own free time. Now, that little book, I mean, is compulsory reading for any student of trial advocacy. It's compulsory reading. Everybody must read Morley's The Devil's Advocate. Every student of trial advocacy must read. It's a little book, easily readable. It is, you can read it in the matatu with the full volume on, which you people like very much. It's, it's easy to read. It's not your typical textbook with footnotes and whatnot and what. It's very easy to read. So everyone must read that book. Small. You can read it in less than an hour and you are done, actually. Well, now, Morley gives us a list of some 10 items, which he calls the 10 commandments of cross-examination. And I think it's a fairly good summary of the do's and don'ts. Number 1, he says, think commando. Think. He does not, note carefully, he does not say go commando. He says think commando. Think. The cross-examiner must always have the mindset of a commando. What do commandos do? Well, these days, a lot of warfare is conducted using unmanned aerial vehicles, otherwise known as drones. But some of you, I'm sure you've read a lot of literature on warfare. Commandos are very, very important people in the army, in the military. In the US, there are these guys called the Navy SEALs. The Navy SEALs are typically commandos. These are fellows who are highly, highly, highly trained. Highly trained. They can operate on land, in the sea, in the air, everywhere. They can go behind enemy lines. They can they're used for surveillance, reconnaissance, assassinations, abductions, whatever. You know how they operate? Go in quietly, get what you want, and get out very fast. That is their modus operandi. That is the modus operandi of commandos. Go in, get what you want, and get out very fast before the enemy detects even your presence. And so, some of you may have read, read, because I know when this happened, you are little toddlers. Maybe you want to read the story of how the US Navy SEALs went into Pakistan to grab this character known as Osama bin Laden. That's a typical commando operation. Therefore, Ian Morley is telling us that a cross-examination is a raid and not a siege. Hey, this is the language of warfare. But I don't like it very much. It confuses the student. The student begins to imagine that a trial is a fight, is a war going on. Nothing of the sort. It's a storytelling business, only that we are borrowing this warfare language. A cross-examination, you don't go there to lay a siege on the witness. It's a raid. Raid, not a siege. You don't go and camp at the gate of no. Go in, get what you want, and get out very fast. Number two, Morley says to us, when you have got what you want for your closing speech, stop. Stop, stop, stop. As soon as you get what you want, stop. Not one step further. Not one question further. Never. Never. As soon as you get what you want, stop. A very nice, beautiful cross-examination can be ruined by one last fatal question. One last question can turn out to be fatal. And that is why I've said to the group 20 here, as soon as you get, the aim of a cross-examination is to get material for your closing argument, to get certain concessions, admissions from the witness for your closing argument. And as soon as you get it, you stop. You stop. Not take one question further. Witness, the time of this incident was about 7 p.m. in the evening. Yes. Darkness had already fallen. Yes. You are about 100 meters away from the scene. Yes. You have finished your cross-examination on that point. The foolish lawyer will then go in, assuming they are moving in for the kill with this extra question. Hey, therefore, if it was dark, you are 100 meters away, how can you say you saw my client biting the ear of the... Oh, you have ruined the whole thing. You have ruined the whole thing. I'm sorry. You know what? There will be a re-examination after you are done. If the re-examiner succeeds in curing whatever things you left hanging as a cross-examiner, well and good, that is up to them. That is why the law is providing for this third step. Now, I know some of you are sitting there and saying, but isn't this guy teaching us manipulating the court? Doesn't this sound like manipulation? Are we not here to tell the truth, the whole truth, and nothing but the truth, so God help us? Yes, we are. But everybody does their bit. You do your exam in chief, I do my cross-examination. If you wish, you can do your re-exam. Oh yes. Oh yes. As soon as you get what you want for your closing argument, stop. 3, never ask a question to which you do not already know the answer. This one, we don't like saying it very loudly, just in case the laymen hear us. We like saying it softly. When lay people hear us saying this, they will be saying, kumbe these lawyers are just thugs. Kama anajua jibu, kwa nini anauliza swali? Look, this is so important. Cross-examination is not a fishing expedition where you cast in your net or your fishing line and pray to God that you catch something edible. No, it is not a fishing expedition. Instead, cross-examination is a very highly controlled business going on here. Never ask the witness question whose answer you do not already know. Oh, it can shock you. And that is why the open-ended questions are no, no, no. The W questions in cross-exam, excuse me, no, no, no. Number 4, always ask leading questions. Enough said of that already. 5, never ask the witness to explain. Never ask the witness to explain. And this is related to number 7, which is never ask the witness for help. The easiest way to lose control of the witness is to ask them to explain something, is to ask them for help. Excuse me. Excuse me. The why question is a no, no, no in cross-examination. Never. Never, ever, ever ask the witness why. Never. As from 21 will be 22, I think, will be telling us the why question is the business of the examiner. Oh yes, never ask for help, never ask the witness the why question, never. 6, reserve your comment to the tribunal, to the fact finder. Never ever comment on the witness's answer. Do not editorialize, do not comment, do not say how beautiful the answer is, do not say how bad the answer is. Never. Always wear a poker face. Well, so I think some of you play poker, don't you? Poker face. If we were in physical class here this morning, I would have required that all of us sing together the great words of now the late Kenny Rogers in The Gambler. The Gambler, you can go and Google it. Those of you who have no idea what I'm talking about, because the only music you listen to is mikono juu, oh mikono juu now, and you claim that that is music, which is just noise. Everybody go and take a little bit of time to listen to the great words of Kenny Rogers in The Gambler. The Gambler is a cross-examiner's anthem. The great musician wasn't a lawyer, but The Gambler is a cross-examiner's anthem. I say to you, don't comment. Reserve your comments for the closing argument. Don't comment. You ask a question, the witness answers, yes, no. If you need further clarification, go ahead. Don't comment. Don't say how great the answer is, how bad the answer is. Never. Number 8, one question at a time. Not 2, not 3. 9, when putting your case to the witness, tell the witness he disagrees with it. This is very powerful. It's a bit of psychology. It's okay to say to the witness, I know you will not agree with me, but this is called putting your case. But while we are on this point, good people, I want to ban, as I do every year, I want to ban, B-A-N, I want to ban this infamous expression that I hear in our courts every single day, which is, I put it to you, I put it to you, I put it to you. Don't put it to anybody. That statement is meaningless, is valueless, adds nothing of any use to your case. Don't use it. I put it to you that you are lying. Foolish lawyer. So you expect the witness to then, yes, I am lying. Is that the answer you are expecting? Forget it. Finally, Keith Evans, Ian Morley says to us, remember to bounce for confrontation. Remember to bounce. This is not about bouncing all over the courtroom, walking, turning and looking at the spectators. No, nothing of the sort. What Molly is saying to us is this is about perception, bouncing questions off the witness. And he gives us a very beautiful example, which I want everybody to go and read, on this lawyer cross-examining a witness in a case of assault. And what is the case theory? Self-defense. See how the lawyer, the example that Molly gives there, bounces off questions of the witness. Look, you don't go to say to the witness, my client struck you in self-defense, isn't it? Hapana. Self-defense is a conclusion of the law based on certain facts. You bounce off questions of the witness, which will lead us to the conclusion, yeah, that really was in self-defense. And so our homework is as follows. Everybody select one witness in Desmond's case, another witness in Mwene's case, and prepare to cross-examine them. Now, I've been requested to donate my Monday slot to civil litigation. I have grudgingly accepted. So we will not meet on Monday. Our next session will be Thursday next week. So it will be a moot court session Thursday next week, where we will spend the whole session doing cross-examination of witnesses. See you then next week, Thursday. Cosmas, what is it?
Mwalimu, I have a question, but I see that time is not on our side.
Yeah, let's deal with it next week.
Thank you.